Hi, I'm Marisa Stranges. Welcome back to Nichols Family Lawyers YouTube channel, where we delve into family law related topics that often arise during divorce or separation. Today we're going to look into how HECS debts are treated in property settlements, specifically the circumstances which influence the court to classify HECS debts as a joint or personal liability. With the rising cost of tertiary education, it is now common to see sizable HECS or HELP debts appear in property settlements. A common question that arises is how the Federal Circuit and Family Court of Australia will deal with these debts. Depending on the circumstances, the court may treat them as part of the asset pool to be shared between the parties or as a personal liability that remains the responsibility of the individual. When deciding whether to include HECS debts in the asset pool, the court considers the individual circumstances of the case, but will often be guided by the following factors. The first factor is whether the HECS debt was incurred during the relationship and if the undertaking of the study was agreed by the parties. The second, whether the debt constitutes a current liability or a contingent liability. The third, whether the debt is contingent, the likelihood of the debtor earning above the repayment threshold and commencing repayments, or whether it is to remain likely contingent. Whether the qualification obtained has been used to generate income during the relationship and whether that income benefited both parties, whether the other party also had a HECS debt and whether repayments were made on that debt during the relationship. So what does this look like in practice? There is no one way the court determines whether the treatment of HECS debts in asset pools. Therefore, it is useful to look at prior cases to determine the circumstances which have influenced the court in treating HECS debts as a joint liability or alternatively a personal liability. In the family court case, a 2008 case of Partington and Cade, both parties had HECS debts of roughly similar amounts. Neither had gained employment in fields linked to their qualifications, nor was repayment likely. Each party remained responsible for their own debt in this case. In another case of Tome and Painter, a family court case of 2015, during a 14-year relationship, the wife incurred a HECS debt, but only commenced employment after the parties were financially separated. The court found that her qualification did not benefit the relationship during its course, and therefore the $13,229 debt was treated as a personal liability. HECS debts are often raised in property settlements, and their treatment is nuanced. Given the potentially large sums involved and the way the court may consider them, seeking legal advice can be essential. At Nichols Family Lawyers, we have expertise in handling complex property settlements. Please do not hesitate to contact Nichols Family Lawyers on 03 9670 4122 for further guidance.